Good afternoon. We had a very nice discussion, first of all, and we already entered India, and this I'm going to talk about. But first of all, I welcome you all in this midst of Anthropocene, and in the middle, early Anthropocene, and high advent of anthropogenic harm. I wish you a happy Diwali. We are going to celebrate. There is Supreme Court watching over us as to the amount of green crackers that we can fire. Thank you very much for inviting me to this marvelous event. Adrian and Surya and David, Niraj, and distinguished colleagues of the institutions for to this marvelous event. I must apologize, first of all, for my erratic presence at this event, wonderful though it is, because of many factors. But one of the factors is that as I was telling Kamla, whom I thought would be gone, that I live among 4 invalids. My wife had a spinal fracture and she's recovering now, and I have to look after her. My daughter, who is teaching at JNU, had some health problems with the onset of Diwali. I myself recovering, it's a long time, sometime, from a stroke. And I've forgotten most of it happened on the right side, and I've forgotten, as a result, on the left side, many of the things I used to remember. These are 3 invalids. The 4th invalid in the house is the Constitution of India. So I have my hands full with care and caution in dealing with the situations. So I'm sorry that I'll be coming and going, I will not be consistent presence I would like to be. I think what we have done here is, I'm very glad to know from Professor Street that we can justify the NJSC decision in terms and from a particularistic perspective. Because, to quote his words, we have and I quote him, a long and democratic tradition. I feel very blessed by this, but before I come to his views, let me quickly deal with 5 or 6 points, very briefly, because I know the time is not available for fuller discussion. The first question we have to ask is, how many decisions about judicial appointment, how many judges' cases, in short, exist in India? Normally, we count 3 judges' cases. The first judge's case, the advisory opinion in 90s, and the NJSC case. My friend Pinky Anand, who is the Additional Solicitor General of India, made me aware that there is a 4th NJSC case. And the 4th NJSC case is about a peculiar Indian situation called Memorandum of Procedure, Transparency and Accountability, on which many of the decisions of the present government are based. So that's the 4th. To my mind, the 5th decision, NJSC 5, which should really be NJSC 1, which deals with the idea of recusal. I was very interested in the Belgium situation that you presented, because in NJSC recusal 5th or 1st, whatever you name it, case, in the NJSC case, half of NJSC case is devoted to the theme of recusal. When can a judge not sit on the bench? and other half is dealing with judicial appointments. Unfortunately, very few scholars deal with the issue of recusal. But issue of recusal is fundamental, basic to the case. In short, I've spent several paragraphs in my anti-paper paper, which is before you. In short, it was one position is that if lawyers mention or whisper that a particular judge should not sit on the bench, the judge melts away. His constitutional presence melts away. He goes away. And some other judge is appointed. Justice Kerr and his brethren in NJSC said a loud no to this idea. And thereby they broke a constitutional convention of long standing, which resulted in what I call asymmetric relationship between the bench and the bar. The bar was in a position of dominance. If you always say, we don't want you as a judge, hear this case. And the mere fact that you are not wanted achieved what is called forum shopping. And Justice Kerr refers to this particular idea as a psychological war game of pressure on the judges. So that is one. The second was if you had a pecuniary bias in the case, a personal bias, then you would recuse. The third situation was when you told the Chief Justice you would rather not, a judge's own volition. The fourth situation was official bias. And many judges would say there is something called, in fact, there is a rule of Indian administrative law, which Professor Singh must be teaching, namely, you will not sit in a particular position to judge a case when you are officially biased to take a decision a particular way and no other. Now, it was argued by lawyers that certain judges should not sit on the case because there was an official bias, that they would uphold the independence of the judiciary. That's official bias. Or they would uphold the supremacy of the Chief Justice, which is official bias. And the judges said in this recusal moment, they said official bias is not to be taken into account and cannot be a ground for recusal. This is again accord with the Belgian position, as I understand it. Very interesting comparison there. And therefore, the judges said only when there is a constitutional litigation between the lawyers and the judges on the issue of financial bias, demonstrable financial bias, pecuniary bias, should a judge recuse. Two judges, one Adarsh Kumar Goel, Justice Adarsh Kumar Goel, and Justice somebody else, which I may note, two justices, Justice Milan Loko, in the NJSC case, in the recusal part, said, well, judges should give, at least as Loko said, give their reasons in writing for recusal. If they have to recuse, they can't just recuse saying we are going off. And Justice Goel and Justice Chalmeshwar said in that case, as you no doubt Indian colleagues know, they said, well, look here, you cannot argue official bias because by definition, every judge must uphold the independence of the judiciary against the executive or the market. You can either have economic independence or political independence. So, it is very interesting that all the five refused to recuse themselves. And that's how they can decide the particular case. The second question I wish to ask, if I can find it, is therefore, First decision you have to make is how many judges' case one is considering. 1, 3, or 4, or 5. And does it make a difference? The second issue that you have to consider, I think one has to consider is, and it's worldwide. I was hanging by my ear to catch the word epistemology, but it didn't come in your presentation. No problem, but it's a slight problem with me, peculiar. That is, how do citizens know who are going to be their justices? And that's a very major matter of democracy. Are the super citizens going to appoint one of their own as their lordships? Is there a method by which judicial review or judicial independence can be structured on basic democratic principles? I would not speak about this, but this is certainly an issue, and I take the view that citizens would never know how judges are appointed in any jurisdiction. Because we have a Right to Information Act, but Supreme Court has said to pronounce whether the Right to Information Act extends to the judiciary. Now 10 years. It doesn't give us the information. So how is an ordinary citizen to know which sorts of super citizens are adopted, as elected, appointed, elevated as justices? It's a big epistemology. We don't know whether I cannot say to you, and you might be able to say it on a study of the world as a whole, I cannot say on my study of India as to whether we are better off in the executive-dominated system, where the executive appointed the judges, or in the collegiate system, where the judges appoint their own. Because I have no means of knowing how judges are appointed in the first place. So the heavy, thick veil of ignorance cast over citizens. And I pose it a problem. So epistemological problem is there is no way in which we can, ordinary citizens can know how judges are appointed. Should there be a way? That's also a question. I don't detain you with this. The third area I want to consider, and I simply mention it, do these judges' cases in India represent an imagination, a constitutional imagination of what India should be like, constitutional India should be like? When they speak about independence of judiciary, democracy, basic structure, essential feature, are they articulating discourse of a particular kind? And are they speaking to the future of India, or any country for that matter, when they insist on this particular idea? And I think on the imagination, there may be a number of questions. Now finally, our last 2 or 3 areas I want to touch very briefly. Coming to the NJSC case, that is judges being appointed by judges. That's the propaganda. That's the propaganda, heavy propaganda. Now how do we deal with propaganda versus precedents? Propaganda doesn't do anything. We just look across the world today. Fake news. There's no such thing. Alternative news. There's no such thing as news. Where governance by rumors and governance by aggression and governance by misogyny or governance by apartheid is the rule. And democracy is an exception. When that is the governance by exclusion is the rule all over the world, where no longer do the liberal values count as values anymore. If you look at the world today and its future, the question is how to disengage propaganda from precedent. Our poor judges do not have time for propaganda. Some have, some political appointees might have, but generally, their task is to do justice under difficult circumstances. Their task is to produce a legitimate disappointment in one party or the other, but a legitimate one, or uphold one party or the other. And therefore, I think the judges should go by a broad sense of precedent, and that's what they have done. That's exactly what they've done in NJSC cases. They have said that the first judge's case, the second judge's case, the third judge's case, we are bound by the precedent, we have 5 judges bench. And they have said that it goes against basic structure for the executive to appoint justices. In 1993, there was an advisory opinion by the President of India, which said, we do not question the institution of judicial collegium. We only raise questions about how it should work. I'm summarizing that, there's a long, proper formulation. And the judges said, well, instead of 2 senior most judges, 5 should constitute a collegium. Nowhere was the method of appointment by the judges questioned as judges appointed judges in 1993. So why this propaganda? That's a different question to which I gave a number of answers. It's propaganda basically assails the independence of judiciary. That's the idea of propaganda here. That will be left aside. The second idea that judges relied on was, look, the Law Secretary of the Union of India has said in an affidavit, government filed an affidavit, Union of India is a continuing of entity under the Constitution. Regimes might change, governments might change, but the Union of India is a continuous body. The Union of India is the largest litigant. And can litigant appoint judges? Now, this is a universal question. It's not just Indian question. I'm telling you what Indian judges raised. To which there was no satisfactory answer. How can a litigant appoint a judge, accepting what's called ADR, or arbitration? We can appoint a judge, I suppose. One this side, one that side, one chairperson. But in a judicial setting. Now, if the Union of India realized in 1993 that they cannot appoint judges, and they filed an affidavit which said out of 395 appointments made, only in 7 they disagreed with the Chief Justice of India. This affidavit. The judge is relying on the past judicial documents and precedents, said that it has been the practice since 90s that judges appoint judges, that executive has no place, and that executive agrees with the judges appointing themselves. Now, what was the need for a judicial commission in this circumstance? Maybe Parliament felt a need for a judicial commission. That comes the genesis of NJSC and Sofia after this point. Parliament, by unanimity, had an amendment and a law appointed a judicial commission. This was challenged, and the court said, this commission is unconstitutional, and otherwise it stinks. Why it stinks? Because it does not preserve the primacy of the collegium, of the Chief Justice and the 2 other judges who are appointed to the commission. Other members of the commission include the law minister, namely the executive, namely the prime minister. Because law minister is appointed by the prime minister. And about 2 eminent persons were included, And Justice Krishna Iyer, one of the greatest judges of our times, Justice Krishna Iyer wrote to me a letter when I became the Vice Chancellor of South Gujarat University in Surat, in which Krishna said to me, congratulations, you now become educationist, you become Vice Chancellor. But I was surprised that he wrote me a letter, but of course the thing in the tail, he always had something to say, worthwhile to say. The second paragraph of the letter said, but Bakshi, always remember George Bernard Shaw, who said, the more eminent a person is, the more things she has done to be ashamed of. You can't become eminent without some skeletons in the cupboard. And who knows it better than me too? So, there is or many other people. So, eminent persons was a category. The justices said they have not been defined. The criteria is not given. In other words, they said the two eminent persons, the law minister and the law secretary was the convener of the collegium. They said this is a total assault on basic structure. And therefore, they struck down. Now, the amendment and the bill, excepting one judge who did not bother to strike down the bill, he was with Justice Chalmeshwar. His opinion is worth reading because in capital letters he uses the word constitutional courts. So India does not recognize constitutional courts. India has no constitutional court. In the Supreme Court is a court of miscellaneous jurisdictions. You can go in state sex, you can go for public interest, any number of matters they would deal with. What the NJSC finally says is this particular bill and amendment, act and amendment, are set aside. It does not say that Parliament of India can never, ever put an alternate method of judicial elevation in its place. So if you remove the constitutional vices that judges have pointed out in the present commission, and if you had the imagination of an alternate commission which was more concerned with constitution, as the lordships have declared, I'm sure it will be upheld. And I've said this to the law minister and people that seem to matter, number of times, that there is a scope for a proper commission, which will take the spirit of the judgment. I, in fact, told the law minister, and I read in the press also, even before the NJSC was filed, that there should be a matter for advisory opinion. The president should seek an advisory opinion on how to appoint judges instead of going through as an adversary. But they didn't. They had their own constraints, and they decided to go as an adversary. I think not all is lost. If one is in favor of a commission, rather than judges appointing themselves as judges, a different kind of commission can be constitutionally imagined. And here it is that the comparative experience could be of great use. So with that, I say only one thing, and only one thing: beware of propaganda. And beware also of precedents, but not all that much in the face of propaganda. Thank you very much.
Thank you. I think we'll have questions for both the papers together, but before that, just a couple of things. When both the papers were, they sort of gelled very well together, because one of the points you were making was whether, and it was just striking me since this is an association of constitutional lawyers, whether over a period of time there's been a flattening of diversity and a trend towards greater uniformity. And you chose to describe India as a particularist example, but I have a feeling that there's also a lot of reasons to treat it as an exception rather than a particular example. So whether it should have been treated as a case of Indian exceptionalism, and there is a loss of diversity in some senses, of modes of, there is a huge propaganda that whether the development of comparative constitutional law has led in some senses to a loss of particular forms of judicial appointment, and whether this is something that should be celebrated or actually the reverse of it. I'm not very clear. I just had that sense that there is a flattening of the world and there's a loss of diversity and greater uniformity, and I'm not sure that I particularly like it coming from the global south. Yeah, so I think I can see many hands up. I don't know, I must ask Surya. We're a little out of time, so if you... Yeah, but we started 10 minutes later. Yeah, okay. So could we just take various questions one by one, and then we have... Yeah, so I'm going up by the hands that came up, and that's you and David and then Uday. I'm sorry, I don't know your names. My name is Kamala Shankaran.
Okay. Hello, I have a short question for each of our two speakers. Thank you for those really wonderful presentations. For Professor Shetreat, of all the models that you spoke about of judicial appointment, there was one which you didn't mention, on which I'd really value your opinion, and that's the practice, which is surprisingly widespread through the world, of appointing foreign judges to courts, which seems to me to place particular pressure on the notion of representativeness, and I wondered if you had something to say about that. And for Professor Bakshi, thank you for that very nuanced presentation of the NJAC case, from which I learnt a lot. I was intrigued by your suggestion that there might be a way to reshape the appointments process, which moves away from current practices and is still consistent with the Constitution. I wonder if you could say something more about what that would look like in your view.
Because it seems to justify practices on the basis that they have a long tradition. And this to me does not, this is not something that, as I understand it, the body that you set up or that you engage with is meant to set certain normative standards of judicial independence. And so to give perhaps a strong analogy would be to say something like that we often hear arguments of culture, like female genital mutilation is justified because it's a long practice, and therefore it's not inconsistent with fundamental rights. And the same is true over here. I mean, I think clearly England, the example of the Lord Chancellor, is a clear violation of a principle of how to appoint the judiciary, and it's not because it's in the global north, it should simply be recognized as acceptable. And you gave a lot of examples from the global north. Why does that make it at all acceptable? Actually, we need normative standards which basically provide the ground for criticism universally, and that should apply across the board. And those normative standards may be more or less realized in certain cases or not, but we should not, just because there's a long tradition, accept those kind of standards. And I think particularly if you have a look in many of these contexts, there's a whole loss of one of the very main issues, for example, is gender, right? I mean, if you actually have to look at the UK tradition, I mean, the number of women judges, at least I know there's an attempt to address this, but it's for a long time been a serious issue. And I think that's true across the world. So it seems to me that what we need to do if we're going to grapple seriously with this question is actually think about what kind of constitutionalist, what kind of design is going to lead to more optimal, or perhaps there's a few different designs to lead to more optimally to independence. But we should not simply accept the fact that they're established traditions and that's a sufficient justification for a particular practice.
Thank you, Professor Shetreat. Usually there has been the idea of the judges as magistrature, independence of the political power and neutral over the conflict of the parts, respect by the society. Olympus, in the god, goddess in the Roman Empire, But this idea of ideal judge was according with an old idea, too, of the rule of law. But it is changing because the government, basically supported by the act of parliament, is transforming by the rule of law based by the constitution and international treaties, where the judge has another task as control the excess of the parliament power of and the government, and to rule according to the international treaties and decision of international tribunals. In this way, according to the legitimize and constitutionality of judicial appointment, which is the profile of judge that require the rule of law in a modern democratic constitutional law regime. Lord Lyndhurst said when somebody asked him who must be to be a judge, he said, a good man, and if he knows a little law, better. Thank you.
Thank you very much. My question, Professor Chitrit, goes to the idea of constitutional design. And I like it very much, the way you present it. You introduce some basic ideas that are underneath in a political system. Just for example, you say the idea of representativeness, of effectiveness, of accountability. So here what my question comes. I think that perhaps there are some dilemmatic or even trilemmatic issues at stake in the face of constitutional design. For instance, in countries that need judges and courts to be loaded with some kind of democratic legitimacy, as they have the power to strike down, for instance, bills and statutes. It's different, if you have a dispersed constitutional review model, as we have following the US system, as you have a constitutional court. So here, I would like you perhaps to develop this idea, because if we are talking about several aims at the same time, I would say that there is not a zero-sum logic, and perhaps you must to sacrifice and to maximize some of these aims. For instance, if you push forward independence too much, you will sacrifice democracy legitimacy, and yes, and all the way around, if you try to bring about more legitimacy, you can, undermine independence. So I would like you to develop on this idea.
Yeah, thank you very much. My question is to Professor Chitrit. You have given a wonderful kind of indicator for judicial independence. What role do you see for post-retirement appointment as one of the important indicators, particularly in those jurisdictions where there is a time-bound appointment? Whether post-retirement factor should also be taken into account for evaluating judicial independence? Thank you.
First, thank you for a very interesting lecture. My question is about your conceptual division between universality and particularity, which I think is very important for this discussion. Can you please elaborate on which particular circumstances that are acceptable to take into account when assessing the legitimacy of a specific procedure of judicial appointments? What are the criteria to decide on this question?
First of all, to say thank you very much, because your presentation has been very, very suggestive, very amazing. As a brainstorm with the different models, a lot of ideas concentrated, so thank you very much. My question is very brief and very simple, because I consider very, very important the idea to distinguish between reflective and representative. So, which is your opinion about the necessity when we are designing procedures in order to appoint judges? Which is your opinion about the necessity to separate proposal bodies and appointing bodies? Because I consider that is a very important idea. And the second question could be referring to the necessity to make true in practice the distinguish between reflective and representative. What happen with the models that don't take into account lay members inside the proposal body to appoint and appointing body? So it's necessary to have women, it's necessary to take into account black people or specific minority ethnic people when we are not only proposing or identifying candidates that after that should be appointed, but also in a specific moment to appoint them. So it's necessary to introduce, I have named eye fresh, in order to, the graphic idea could be to put the whole eggs not in the same nest, in different nests. In order, when you are thinking, for example, the landscape, people cutting trees in a forest, it's very important to avoid the fire, to make a way fire, breaking the possibility to spread very quickly the fire. So in those sense, it's very important to distinguish between proposal body and appointing body, and to take into account the necessities claimed by the society in terms to women, minorities, and something. So thank you very much.
There are more hands, but I think that can be over lunch.
Or probably we take questions.
We can.
Because I think it's better to take questions rather than the answers, because the answers may not be perfect. Or I think this is good. Yeah, so, and probably Celine wants
there are
to,
three more.
let's get, and I
All
also
the
have a
questions.
question.
Okay, but you're the third. There's 1, 2, and then 3.
Thank you very much. My question goes to Professor Shetrit as well. You referred the distinction between the ordinary regimes and the emergency regimes, rightfully actually. We all know that the emergency regimes are the constitutional regimes in democracy, in democratic constitutionalism at least. So in your view, where does the judicial independence stand in emergency regimes? Thank you.
There's one question here and then.
In the case of exact Supreme Court said it is a matter of time to see whether the people of the society are mature enough. Okay, so in Enjak's judgment, Supreme Court made a statement that it is a matter of time to see whether people of society are mature enough or not. So considering that India is like the largest democracy of the world, so how do you justify, what are your views on this? And Professor Srijit said the judiciary is reflective of society. So if it is the fact that like people of the society are not mature enough, how do you justify that judiciary is reflective of the society?
Okay, my question is very simple and brief. Are we trying to answer a wrong question? Instead of focusing on who should appoint judges, should the focus be on how are judges appointed?
So, yeah. So, one of the things which worries me is this, that when we talk about appointment of judges, we are essentially talking about more so when we are talking about system like constitutional courts, that the judges who are aware of constitutional goals which they are supposed to protect. Now, if it is not taking into consideration those kind of ideas, then what worth is of independence if they are not willing to go for an interpretation which strives for achieving constitutional goals. So if it is only about collegium or judges appointing themselves, I think that will be a huge problem, that whether they are taking into consideration a constitutional goal which may be less libertarian, more society concentric, that kind of idea.
Well, uh, in my cabinet time, one of the portfolios that I held was being in charge of television channels.
So the final 1 minute.
I gave this concessions to the companies. So there is television time,
Yes.
there is radio time, and there is public radio time. So we are using television time.
1 minute.
So, for Adrian, appointing foreign judges exists, for example, in the solution of Bosnia-Herzegovina. They brought in 3 outside judges. It exists in Dubai, DIFC, Dubai International Financial Center. They bring judges from England, Hong Kong, Singapore. I'm not sure it helps. I know a certain case that it didn't help. So the system of bringing non-national judges into domestic courts is one of the systems to ensure at least a certain public confidence between 2 conflicting ethnical groups. So that is in existence. A long and democratic tradition has to be really long and has to be really democratic. If you apply to South America during the juntas, that's not my argument. I'm talking about a country that has proved to be democratic and long time democratic. So that's why my test is not so difficult to apply. And you can bring very extreme cases. They are not in my, they don't fall within my test. Cesar, you are absolutely right that character of the judge is more important than the knowledge, but I don't think we want to have ignorant judges, even though they are top quality in character. I think we have to have a balance. Good judges with good knowledge, but if you ask me which one to prefer, if I had to, I would have a good character than a very knowledgeable without good character. I think that reflective and representative, I think today diversity is accepted. For example, in the 2005 Constitutional Reform Act of England, of UK, England and Wales, it reads diversity specifically. It is practiced. The Supreme Court of UK has 2 judges from Scotland and 1 from Northern Ireland. The Supreme Court of Canada has 3 from Ontario and 3 from Quebec and 1 from the west side, 1 from the east side. So I think it is accepted. In Germany, they call it Rotsenat and Schwarzenat. And there is a kind of balance between who is elected to the Constitutional Court in Parliament. It is based on ideological. So diversity and reflective principle is applicable by practice. We only made the distinction that you don't ask for exact reflection like you do in political sense. And I think I don't have much time, but I will say one word about emergency. Good judicial system will review emergency decisions and executive decisions in emergency time. If the culture supporting the court exists, if the culture is broken, then it wouldn't help, because the whole rules of the game are being breached. And therefore, I would say, assuming the basic structure remains, not in the sense of the doctrine of basic structure, but if the basic democratic structure remains, then the judges have to be active and defend liberty and defend freedom and defend life, even against the executive, because they will get the support of the public. And if the rules of the game collapse, then even the judges cannot do, because they will be taken to prison. They will be hanged. They will be killed, like happened in some dark days in the history of mankind. And I don't want to go into detail of that, but I think, let's say normal emergency means that there still exist the rules. Abnormal emergency and total collapse, the rules don't exist. So I would distinguish between these two. I think it's enough.
Like a true television star as well.
Well, I hate to be pessimist, but the dark days are back again, globally. And therefore, the task of constitutional lawyers everywhere is to find a new enlightenment. We cannot work with old enlightenment. And that's the big question. And that brings me to two comments. One is, as far as I understood you, Adrian, I think question of imagination, what constitution should be like, or political order should be like, is a very big question. But one of the things that we as constitutional lawyers do not think of carefully is the notion of time, temporality, and the constitutional order. And I think that's a very big problem. I think I've counted the legislative time, the constitutional time, the adjudicative time, the amendment time, various ways in which you can classify, understand the notion of time, and thereby build the notion of imagination. For example, one of the examples, I'm very brief, is distinction to be made between episodic and structural. Every issue that is episodic for the politician becomes a structural issue for the judge, at least in India. Episodic is very important for democracy. You have to win the election. You have to therefore run a party, and therefore everything structural is converted into everything that is episodic in politics. In judging, everything episodic is done structural. In politics, everything structural is turned into episodic. And this is very important to me. And on a lighter note, and to conclude my so-called responses, is as to qualifications to a judge and the universality business. I one with David on that. There is a problem of universality and particularity. And the Indian judges have posed the problem, and a very big problem. If governments and states are going to be largest litigants, can they appoint judges? Therefore, how do you construct a universal platform for appointment of judges? If politicians can't appoint judges, commissions can't appoint judges, judges can't appoint judges, then who can appoint judges? And that's a big question. And it's a fractured universality is all we can hope to get. How fractured the universality is a matter, of course, of opinion. But I agree with the general sentiment. And finally, on a lighter note, Kamala, very finally, we had several classifications of judges in India. One classification was those who know the law and those who don't. Second classification of judges was those which are a practicing Chief Justice of Indian Supreme Court himself used, Justice Adatola. He said there are two kinds of judges in India. Those who are forward-looking and those who are looking forward. And there is a third kind of quip about judges in India, and maybe that's useful generally, is there are judges who know the law and judges who know the law ministers. Therefore, all kinds of judges exist. But essentially, we have to think of the element of time and element of structure.